Let's discuss this ruling further now and its implications and really what then does the road ahead have for this particular matter, particularly as far as the defense is concerned. Let's now speak to legal expert Mpumelelo Zikalala. A very good evening to you and thank you so much for your time. So, the judge says at face value there is a case to answer to here given some of the seriousness of allegations that have been made and also the fact that he at some point you can hear what his thoughts are on what the defense has put forward as far as the arguments on this discharge application is concerned. Did it surprise you that this ruling was made?
Good evening to you, Mangata, and also to your viewers. Not really. If you look at how Section 174 is couched in the Criminal Procedure Act, it says exactly that. If it's in the opinion of the judge that there's no evidence or there's no evidence to convict at all, let's underline that particular phrase, then the judge will come to the conclusion of saying, I'm going to let you free. But in this instance, as the judge was highlighting, there are a number of instances or pointers in which accused number 4 has got to come into the witness box or provide evidence to say, this is why I'm dispelling or explaining the purpose of why that evidence is there and why it exists. And if it does exist, it has nothing to do with me and the trial that we are facing now. But if there is, he's quite correct to say, at the end of the day, I can be able to convict you. But what I think accused number 4, legal rep, has been able to do is to source the mind of the judge to say, when I present my evidence, what are the salient points that I need to cover to make sure that I'm able to represent much better the side of the perspective of my client. I think in this case, he was successful in doing that and in bringing what you call isiZulu mbuzi, so that when they present their evidence, they know exactly what to deal with and what evidence to provide in order for them to guarantee an acquittal.
So when you then look at, of course, some of the arguments that, the defense here is arguing to say that, for example, there is nothing that is linking their client to this particular matter and all of that. And one then, as you say, may kind of get an idea as to where exactly they might be headed. So in your view, who then do they need to call when it's their turn to cross-examine, should they decide not to challenge this? Who do they need to call to corroborate all of this?
Firstly, the person that cannot not take chances and must go to the witness stand is accused number 4 himself, so that he can be able to explain and say, yes, I do admit that there are communications and levels in which you've communicated with this individual, but it had nothing to do with Senzo Meyiwa. It had nothing to do with the alleged crime. It had nothing to do with any planning. It was purely something which was outside the preview what was happening here. Now, in order to collaborate or to amplify that submission, then you need to go back and say, let's look at our previous or the history that we've had. We've communicated before, we've communicated during and even after, and still now we are doing so. Hence, we call it either friends or omkaya, people that know each other from somewhere. If you're able to do that and then call independent individuals who will be able to prove that that's going to assist, call the individuals that were there on the day or within the time. Was there any planning that took place when they came in? Were they jittery if they ever came in at all? Explain all those instances and circumstances with one theme in mind. I want to be able to show to the court that I have known this individual for quite a amount of time. I've known them even before. I was already communicating with them. There was nothing wrong with that. And it's purely a coincidence that my name is drawn up on this one. If there's any evidence that says I was there on that particular day, 1 or 2 witnesses which will say I was with him on the day, sitting with him and enjoying a nice meal or a nice drink, will be able to rebut whatever the state has stated thus far. But to simply leave it like this and only rely on accused number 4, I don't think it's going to suffice, especially because you've seen the kind of judge that you have and the type of not to say nitpicky, but to be thorough in the way and comprehensive in which he wants the evidence to come through.
So can they appeal this decision?
Technically speaking, yes, but it wouldn't be advisable to take that 174 to all the way to the Constitutional Court. It's going to provide time delays. It is not going to assist anyone. And even if you look at the merits, then the merits are not there. The Section 174 is written in a way that says it's just the opinion of the judge. Simply on that opinion alone, no technical merits or anything like that, then they have the power to say, we are not going to agree with you. Come and let's listen to the evidence, especially in this case, because there is evidence that is there. There is something and some items in which accused number 4 would need to answer to. So even if you take it on appeal, is not going to assist, it's just going to delay the time and your allocation to the matter and your ability to present the truth to the court so that your client can be acquitted.
So listening to all that you say, right, is it correct then to say that, for example, a discharge does not mean that the accused is found not guilty in the same way as after a full trial? It could mean that the court believes that at this particular stage, there's no legal basis possibly to continue with the trial. Would that notion be correct?
No, it wouldn't. In fact, if you look at Section 174, if it was granted, then it would have meant that he's found not guilty. That's the verdict which the court will deliver. Because remember, let's look at what the court says. I must be able to find you guilty beyond reasonable doubt. That's the test in which I'm putting you in. So if the state has failed to provide evidence, the Section 35 of the Constitution protects you from incriminating yourself, protects you from going into the witness box, even if there's no evidence that is there. So if this application succeeds, the results which is going to bring is the result of not guilty, meaning that you can't be tried again for the same crime because a not guilty verdict has been received on that crime in the first instance. So it would have delivered a not guilty verdict, which is why maybe if they really want to push it, they would say, let's file an appeal and see what we want, because if we are successful in that appeal, it gives us the ultimate price of being acquitted and never being ever tried again in this matter or any matter which is related to this one.
Yeah, it's going to be an interesting road ahead, as you say. Let's see, firstly, if the defense will then appeal this, but also critical to note, will he then take the stand when the time does come? Let's see what will happen there. But thank you so much for talking to us this evening. Really do appreciate it. And of course, that was a legal expert, Mpumelelo Zikalala. This is a story that we'll continue to track for you, as of course the matter has now been postponed. But we are yet to see which way the defense is leaning towards here on this particular matter, because this case has become quite complex with twists and turns. Let's see then what happens.